yesterday, and you will superimpose that on the absence of any factual.
My airport land friend is in the field will address your Honor. Party. That's why I've said that I'm running about in this court.
Let us agree.
Yes.
Decide to address the court in part, then indicate which part you are addressing or which each counsel will address. Please.
I'm going to respond to you.
Yes?
I'm going to respond to Madam colleague.
Yes. Just a second.
We'll be brief, but I want the court to observe that in the thundering voice that my learned colleague addressed you, several things become very evident. One is that the allegation that the accused caused his own absence from court is absolutely without merit. There was, in the course of my colleague's address to you, a concession, given very grudgingly, but a concession all the same, that the accused is in custody. What my learned colleague failed to address you on is that having been in the custody of the state, how could he at the same time be accused of causing his own absence if the same state did not bring him to court? That there is a cliche that is often repeated before you, that is called breathing hot and cold, or approbating and reprobating. That explains why he's not in court. And Your Honor, it has been stated that we are addressing you from the barn, telling you stuff. Exactly what my learned colleague did. That's the job that we have been retained to do, to tell you what the current position with regard to the accused is and why he's not in court. We were told also that there are procedures through which matters are presented to court. Your Honor, the truth is that if it was a civil matter, the Civil Procedure Act is very codified. The Criminal Procedure Code, unfortunately, has not been codified, so that these procedures my learned colleague is talking about can be evident. He did not even tell you what those procedures are, rather than, with tremendous respect, telling us from the rooftops that they are procedures. Pardon?
If it was a civil matter?
If it was a civil matter, the Civil Procedure Code is, the civil procedure has been codified. There are rules that have been presented. You do this by way of notice of motion, 3 days before you serve, and so on. We do not have such codification with regard to our criminal jurisprudence. And the question of parity of information, again, Your Honor, needs to look at this issue in the context of what is very obvious. That when we were here before you last time, you look at your record. What did you order? You ordered that our client be taken straight to Gigiri Police Station, where he was in custody pursuant to an order of the court. Although I don't want to spend much time on it, but your order was flagrantly disobeyed. Instead of him being taken to Gigiri Police Station, he was taken to Kahawa locals.
No, I must object, Your Honor. These are new issues coming up. You remember when I started my response, I said I was not able to discern whether an application had been placed before you for determination or not because they did not volunteer any information. All I gathered was at the end, they asked that this matter cannot proceed, it must be adjourned. That's why I said, if the application is for adjournment, I am responding and I gave my reason. But it was upon them, at the first instance, when they made the application, to give you the reasons to support the application. Not now in their response.
There's nothing new, Your Honor. I was just asking you to look at your record to see what was here and the orders you made. It is on record. My learned friend was not present. I think he lacks the benefit of knowing what exactly happened when we were here last week. Your Honor, this cannot be shenanigans, as my learned colleague says. Let the court take notice of the fact that even when the accused was here last, he actually was produced in an ambulance. That is a fact that cannot be taken away. The point that we want to emphasize, and we want to emphasize it very loudly, is that the Constitution that we are all privy to, and that we're subject to, under Article 50, paragraph F, makes it mandatory for an accused person be present at all times during
That
his...
is 52F.
52F, thank you, Your Honor. Yes, it makes it mandatory. It makes it mandatory for an accused person to be present in court during his trial, unless by his conduct he makes it impossible for proceedings to go on. That's the only exception. No amount of oratory can take away this right from the accused. What we are emphasizing is that we are before you, and just before we are before you, but the accused is not, and the reason he's not is because he's in custody, and he is in hospital. The document that my learned senior, Dr. Hamino, presented to you actually is a document.
I've not seen it.
This is addressed to the DCIO.
Can you just look at it, Your Honor?
I'm raising an objection.
I know why they don't want to see it.
Even the devil wants to know why I'm making an objection.
No, please. Don't exchange words. Just coming inside down.
Yes.
When I raise an objection.
Yeah?
You're number one.
Yes.
When the senior was making submissions to the court, he never served any report or our part in this way. Up to now, when you're making our submissions, we've not been served. We are strangers, and from the first time we've appeared, we've not been served with any medical record. And that is our problem.
Senior said that.
So, we will be objecting to them showing this book.
Yes. Mr. Nyakundi.
Yes, Your Honor. This is a document. The document I'm holding is dated 16th February, and is a document that was presented to us yesterday by the state. Unless the state is comprised of small compartments here and there, we take it that is a unitary thing. The prosecutor at our law courts is from the same office as the prosecutor here. So it is a little disturbing that they would try to object to a document which they themselves generated and produced in court and gave a copy to us.